Hello everyone, this video is in relation to latest landmark judgments that has been passed in the year 2021 to 2022. So we have prepared a list of 30 to 40 judgments. I know there are a lot of judgments, but we have identified few of the important judgments, and this video will be in two parts, part 1 and part 2, and this is the part 1 of the judgment. So, and also one more thing, I know it would be very difficult for you guys to remember the whole judgment and the name of the case laws. So what you can do is just try to remember the catchy terms or keywords which will be helping you in your examination in identifying the judgments or the case law's name. Okay, so let's begin with the judgments. So the first judgment is related to Monirul Molla versus State of West Bengal. So in this case, what happened was, basically this case is related to section 53 of the Indian Penal Code, which basically talks about different types of punishment. So under Indian Penal Code, there are 5 types of punishment which is being given to the accused, the convictor. So the first one is death penalty, life imprisonment, then simple imprisonment and the rigorous imprisonment, then forfeiture of property and fine. So you can remember the types of punishment, because this can be important for your examination. So what happened in this case was, Calcutta High Court issued a directive to trial courts. So basically this was for trial courts in West Bengal, stipulating that a sentence of life imprisonment till death without any scope of remission can only be passed in rape cases. So the further court observed that the sentence of life imprisonment till one's death can only be imposed by the higher judiciary. That is, so higher judiciary mein Supreme Court and High Court. So now they are having the power to give the life imprisonment till one's death. So that's the reason this is the important judgment. So the next one is Delhi Airport Metro Express Private Limited versus Delhi Metro Rail Corporation. So now this case is related to arbitration. Section 31. So 31 talks about what? Forms and content of arbitral award. So when the award is being passed by the arbitrators. So what are the things they have to follow, how the arbitral awards will be passed, and all this time. So in this judgment, basically they were discussing about the interest. See, with agar arbitral award ke saath, if there is certain interest needs to be attached or not. So the question, basically the issue in this case was, can an arbitral tribunal award interest if parties have agreed otherwise? So the point is ki arbitrators जो होंगे, arbitrators decide करेंगे कि what will be the interest rate, और the parties decide करेगा कि what will be the interest. और अगर parties decide कर चुका है कि ये interest होगा, so can arbitrators go beyond that? So in this, basically Supreme Court held that when the parties have an agreement between themselves, so अगर parties खुद से decide कर चुके हैं that governs the issue of interest, the arbitrator would lose its discretion and will be guided by the agreement between the parties. तो जो parties ने decide किया था while entering into an agreement, that will prevail over the arbitrators. ठीक है? Now moving forward, the third judgment is related to Mahesh Lal NY versus State of Kerala, which is related to Article 30 of Indian Constitution. Article 30 is first of all for the benefit of accused. So basically Article 30 talks about 3 things: ex post facto law, double jeopardy, and then the self-incrimination. So this is in relation to Article 30 clause 3. So basically it talks about self-incrimination. No one can be witness against himself. Okay. So in this case, what happened? Kerala High Court ruled that the consent of an accused is not necessary to acquire their voice sample for the purpose of comparison, since it has already been established obtaining that voice sample of the accused do not infringe Article 30 clause 3. So now basically Article 30 clause 3 क्या कहता है कि no one can be witness against himself, but there are certain things which will not amount to self-incrimination, like what are those things? Thumb impression, verifying DNA, taking blood samples, handwriting. So all this thing will not amount to self-incrimination. So now there are 2 landmark judgments apart from this which you can remember under Article 3 is, first one is in relation to, you can just note down also, State of Bombay versus Kathi Kalu Oghad. In this case, what was held that thumb impression, verifying DNA or writing is allowed and it does not amount to self-incrimination. Then one more judgment is there, which is like second important judgment under Article 20 Clause 3 is Selvi versus State of Karnataka. Okay? So in this case, what was held? That first of all, this case challenged the validity of certain scientific techniques such as narcoanalysis, polygraphy test, brain fingerprinting test. So it was held that all this test can be allowed if accused give its free consent. So agar accused अपना consent दे रहा है and that consent is free, then it will be allowed to take all this test also. So these are the two important judgments under the Article 20 Clause 3. So apart from that, this is the new latest judgment which you can remember. So while dismissing a petition alleging that the accused was not given an opportunity of being heard before being directed to produce his voice sample, it was held that there is again no violation of that particular article. The next judgment is Arnunachala Gounder versus V. Ponnusamy versus others. So now this case is again related to Hindu Succession Act. So first of all, what happened? In 2005, daughters were also made co-partners. So now they will also be having rights and privileges as a co-partners in their father's Hindu undivided family property. So again, this court upheld that a daughter is capable of inheriting the self-acquired property or share received in the partition of co-partnership property of her Hindu father dying intestate. So one is intestate and the other one is testamentary. Testamentary is with will and intestate is without will when the person is dying. So all these small terms is again important for the purpose of your examination. The next judgment is related to Bar Council of India versus Twinkel Rahul. So now what happened in this case? So basically, person engaged in other employments can be permitted to provisionally enroll with the concerned Bar Council and to appear in the examination. So with other employment, you can also enroll under Bar Council. So on passing of the examination, they can be given period of 6 months to decide whether to join legal profession or not. So the next judgment is State of Rajasthan versus Ashok Khetoliya. So now this case is first of all related to Article 243Q of Indian Constitution, which talks about Constitution of Municipalities. So now what happened in this case was notification was passed by the Rajasthan state government declaring that Gram Panchayat Rupas as a municipal board. So the High Court held that no, this is inconsistent with this article. So later on Supreme Court ruled that the constitutional 74th amendment does not take away legislative competence of the state legislature to legislate on the subject of local government. So local government is equal to municipalities. So it is the state legislatures alone who is competent to legislate in respect of municipalities, with only one limitation, that the provisions of the State Act cannot be inconsistent with the mandate of the scheme of Part 9A of the Constitution of India. So Supreme Court basically upheld the notification passed by the Rajasthan state government. The next judgment is Hotel Priya Proprietorship versus State of Maharashtra. Now in this case, basically what happened? Gender bias. This was held to be basically what? Gender gap. The Supreme Court held that the state has a duty to promote an environment conducive to women's employment rather than frustrate and strangle their choice. Otherwise, this will be in violation of Article 14 and 19 Clause 1 Clause G. So while striking down a license requirement that imposed a gender cap on the number of people who could be on a stage in Ochester's bar. So only 4 ladies and 4 men were allowed on the stage, due to a stipulation imposed by the Commissioner of Police in exchange for granting a license to specific bars. So this was held to be a violation, and later on it was held that the impugned gender gap was a product of a stereotypical view that women who performs in bar and orchestras belong to a certain class of society. The court basically caused the gender gap in orchestras bars, violating the fundamental rights. Moving further, Puliyel versus Union of India. This is again a very landmark case in which it was held that no individual can be forced to get vaccinated and right to bodily integrity of a person under Article 21, which also includes right to refuse vaccinate. So it's your choice to get vaccination or not. No one can force you. The next important landmark judgment is related to sex workers. Budhadev Karmaskar versus State of West Bengal. So sex workers had been brutally murdered for refusing to have sexual intercourse with the accused, which basically led the courts to not only convict him for the act he had committed, but also challenged to consider the bigger picture of the plight of sex workers. So what is the role of the sex workers? What are their position in our society? So basically it was held that court directed UIDAI to issue Aadhaar cards, held voluntary sex workers as legal asked sanitizations of police in such matters. So police जो ऑफिसर्स हैं उनको बेसिकली उनको नॉलेज दिया जाए, उनको सैनिटाइज किया जाए कि हाउ what is the role of the sex workers, that they should not arrest the sex workers. They are having a right to profession under Article 19 clause 1 clause G. So conditions conducive for sex workers to live with dignity in accordance with the provision of Article 21 of the Constitution. So Article 21, Article 19, Article 14, everything is now applicable for sex workers also. Next judgment. Now this judgment is related to sedition. The one of the most debatable case again. First of all, one more case you can remember in relation to this is Kedarnath versus State of Bihar, which actually upheld the constitutionality of sedition and held that this is not in violation of Article 19 clause 1 clause A. So now what happened in this case and what was the court's order? So recently there is a stay in this particular section. No one can be arrested. Okay. So court's order is 152-year-old sedition law under section 124A of the IPC should be effectively kept in abeyance till the union government reconsider the provision. So new arrest nahi hoga. Everything is on stay. All pending trials, appeals, proceedings with respective charges framed under section 124 to be kept in abeyance. The central and the state government to refrain from registering any FIRs. कोई भी FIR register नहीं होगा under the said provision जब तक ये लोग reconsider नहीं कर लेते हैं. Now the next judgment is related to AG Perarivalan versus State of Tamil Nadu. This is again one of the landmark case. In this, the Supreme Court invoked its extraordinary power under Article 142. So now what is 142 first of all? So 142 is basically the enforcement of decree and orders of the Supreme Court. So basically if the Supreme Court feels necessary for doing complete justice in any cause or matter pending before it, Supreme Court can use Article 142. So under this, it released AG Perarivalan in former Prime Minister Rajiv Gandhi assassination case. Not only president but governor is also having. It was held कि सिर्फ president के पास नहीं, governor के पास भी power है under Article 161 to remit, commute, pardon sentences imposed under Section 302 of IPC, like death penalty में. Death penalty basically कर सकता है गवर्नर. Since the executive powers of the state extended to the said provision. So president का power दिया गया है Article 72 में, governor का power है 161 में. This is one of the landmark judgment again. The next judgment is related to Aurelio Nunes versus Union of India. In this case, it was held that there is no prohibition for introducing reservation for socially and educationally backward classes in the PG courses. Court allowed NEET counseling for PG and UG admission based on existing. So now there can be reservation also there will be reservation in PG courses also for EWS and OBC reservation. So basically OWC quota can be introduced in PG courses. Now again, this is one of the landmark cases, Jarnail Singh versus Lachmmi Narain Gupta. So this case is related to again reservation in promotion under Article 16 clause 4A. So now state is obligated, basically this is not mandatory on the state to provide reservation, state may provide. So Supreme Court has basically laid down the guidelines, what are the state government supposed to keep in mind while providing reservation. So state obligated to collect quantifiable data for category regarding inadequacy representation of STSA. So state government thinks that there is inadequate representation of particular caste, then only reservation will be provided, otherwise it's not mandatory. Moving further, this is also a very landmark case, Jayashree Lakshman Rao Patil versus Chief Minister and others. This is related to Maratha reservation. So Supreme Court struck down the Maratha reservation quota, the Maharashtra SEBC Act 2018, which basically provided 16% reservation for Marathas in jobs and education. So it held that there were no exceptional circumstances justifying the grant of reservation in Maratha community in excess of 50%, because this ceiling limit has been laid down in Indira Sohani judgment. This particular case, Jayashree Lakshman Rao Patil upheld the Indira Sohani judgment, and also the challenge to 102nd amendment, constitutional amendment, was rejected. Now, one of your homework will be to let us know in the comment box what is 102nd constitutional amendment. The second thing, you can also let us know till date what is the last amendment done in the Constitution of India. The last case for today will be the Secretary Minister of Defence versus Babita Punya versus Punya and others. In this case, it was held that the judgment upheld the directive principles of equality under Article 14 by providing access to permanent commission to the female populace. So, directed the union government to award permanent commission in army to eligible women officers who were excluded from the same on the grounds of unequal application of witness standards. So, this is the part 1, and we will be releasing part 2 soon. So, stay tuned everyone. And in DU-LLB, they ask directly judgments. So, I request everyone to learn the name of the judgments. This is the latest landmark judgments. So, thank you everyone. Wish you all the best.